The Supreme Court quietly changed 13 gun laws, and almost nobody in the gun community is talking about it. If you carry a firearm and you have no idea what I'm about to tell you, you could be living under a completely different set of rules right now and not even know it. Look, I spend dozens of hours every week digging through court decisions, legal filings, and state responses, so you do not have to. The least you can do is hit that subscribe button right now. Seriously, hit it. Because what I am about to walk you through could be the most important legal information you hear all year as a gun owner. Most people find out about these changes after they have already made a mistake. I do not want that to be you. Subscribe now and let us get into it. Here is what you need to understand first. The Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin did not just change one law. It sent shockwaves through gun law across the entire country. Courts at every level have been wrestling with what Bruin actually means ever since. And in 2024 and into 2025, the Supreme Court followed up with more decisions that kept shaking things loose. The result is 13 significant changes to how gun laws work in America. Some of these changes expand your rights. Some of them tighten restrictions in ways you would not expect. All of them matter if you carry a firearm. Change number 1. The standard for how courts judge gun laws completely changed. Before Bruin, courts used a balancing test. They would weigh the government's interest in public safety against your Second Amendment rights. Bruin threw that out. The new standard says that any gun law must be consistent with the historical tradition of firearm regulation in America. That means the government cannot just say a law is good for public safety. They have to show that similar laws existed back in the founding era of this country. This is a massive shift. And it is the foundation for almost every other change on this list. Change number 2, many may issue permit systems became effectively unconstitutional. Before Bruin, states like New York, California, New Jersey, Maryland, and Hawaii operated under may issue systems. That means a government official could deny your carry permit just because they personally decided you did not have a good enough reason to carry. Bruin said that is unconstitutional. If you meet the legal requirements, you have a right to carry, period. Several of these states fought back hard, but the core ruling stands. If you live in a state that used to deny permits without a clear reason, your right to apply and receive a permit just got a lot stronger. Change number 3. The definition of sensitive places got legally contested. Here's where things get complicated. After Bruin, states started expanding their lists of sensitive places where carry is prohibited. The idea was to use location restrictions as a workaround for the permit ruling. But courts started pushing back. The Supreme Court's guidance on sensitive places says they must be locations with a historical basis for restriction. Places like courthouses, legislative buildings, and polling places have that historical basis. But a parking lot or a public park? Courts are increasingly skeptical. Multiple lower court rulings have struck down overbroad sensitive place designations, and those rulings trace directly back to the Bruin framework. Change number 4. This one surprised a lot of people. The requirement to show a specific need to carry was ruled unconstitutional. In some states, you used to have to prove you were in special danger or had a unique reason why you needed to carry. Maybe you were a jeweler who carried cash. Maybe you lived in a dangerous neighborhood. But Bruin said that is not good enough. You do not have to justify your need to exercise a constitutional right. You would not have to justify why you need to speak freely or why you need to practice your religion. The same principle now applies to carrying a firearm. This change alone reopened carry rights for millions of people in restrictive states. If you're learning things you did not know, I want you to imagine what my next video is going to do for you. I'm covering the exact words you should say at a traffic stop when an officer asks if you are carrying a gun. Those words could keep you out of handcuffs. Subscribe right now so you do not miss that video. It could literally be the most valuable 4 minutes of your life. Change number 5. The Rahimi decision in 2024 added a critical layer to all of this. Here is what just happened with United States versus Rahimi. The Supreme Court ruled that a person subject to a domestic violence restraining order can be prohibited from possessing firearms. Now, at first glance, that sounds like a restriction, and it is. But the way the court reached that decision is what matters for every gun owner. The court reaffirmed the Bruin historical tradition test, but clarified that it does not require finding an exact historical match for every modern law. Instead, courts must find that a law fits within the historical tradition of disarming dangerous individuals. This opened a door that cuts both ways. It confirmed the Bruin framework while giving the government a slightly broader tool to argue for certain restrictions. This is the part nobody is talking about. The Rahimi decision is being used by some states to argue for expanding who can be disarmed under the dangerous person standard. If you have any legal history, any restraining orders, any prior incidents on your record, This decision matters for you directly. Change number 6. Felon in possession laws were put under a microscope. The Bruin framework forced courts to re-examine the federal law prohibiting felons from owning firearms. Multiple circuit courts have heard challenges arguing that certain nonviolent felons have a constitutional right to possess firearms, because historically, firearm prohibitions were tied to dangerous or violent individuals, not people convicted of nonviolent offenses. Some courts have agreed with this argument, others have not. The law is actively unsettled on this right now. If you have a nonviolent felony conviction and you have been told you can never own a firearm again, you may want to consult an attorney because the legal landscape around this is shifting in real time. Change number 7. Age restrictions for purchasing handguns faced new legal challenges. Federal law prohibits licensed dealers from selling handguns to anyone under 21. But under the Bruin historical tradition test, challengers argued that historically, 18-year-olds were full members of the militia and had the same rights as adults. Several courts have wrestled with this. Some have upheld the age restriction. Others have struck it down. This is an active legal battleground, and the Supreme Court may need to weigh in again to settle it. Now, quick legal note. Everything I'm sharing in this video is educational information only. It is not legal advice. Every situation is different, every state is different, and laws are changing constantly. Always consult a licensed attorney who specializes in firearms law in your state before making any decisions based on what you learn here. I am here to inform you, not to represent you. Now let us keep going. Hey, quick check. Right now, the majority of people watching this video are not subscribed. That is wild to me. You are watching a video about laws that could send you to prison, and you're not making sure you get the next update. Do not be that person. Join the tens of thousands of gun owners who trust this channel to keep them informed. Hit subscribe right now. It is the smartest thing you will do today. Change number 8. Red flag law challenges intensified after Bruin. Red flag laws, also called extreme risk protection orders, allow courts to temporarily remove firearms from someone deemed a threat. After Bruin, multiple legal challenges argued that these laws violate the historical tradition test because there was no founding era equivalent. Courts have ruled differently on this depending on the jurisdiction. Some have upheld red flag laws. Others have found due process problems with removing firearms before a person gets a hearing. This is still being litigated heavily, and the outcomes will vary by state. Change number 9. Regulations on firearms suppressors and certain accessories were challenged. Here is a hypothetical example to explain this. Imagine a gun owner in a state that bans suppressors argues that suppressor bans fail the Bruin historical tradition test. Because suppressors did not exist at the founding and therefore no historical tradition of banning them exists, some courts are now grappling with exactly this type of argument. The logic cuts both ways. If there is no historical tradition of banning something, maybe it cannot be banned. But if there is no historical tradition of the item existing at all, courts have to figure out what the closest historical analog is. This is a legal frontier that is moving fast. Change number 10. Magazine capacity restriction cases are working through courts under the new standard. States with 10,000 round magazine limits have faced renewed legal challenges under Bruin. The argument is that, historically, there was no limitation on how many rounds a firearm could hold. Courts in California and Illinois have seen significant rulings on this. The 7th Circuit and the 9th Circuit have both issued decisions on magazine capacity limits, and they do not agree. This disagreement between circuits is exactly the kind of thing that forces the Supreme Court to step in and settle the question. Change number 11. Public carry restrictions in sensitive areas connected to government assistance were challenged. This is one most people have never even heard of. Here is what just happened in some cases. Plaintiffs challenged laws that prohibited carrying in public housing or in areas around government benefit offices. The argument was that poor people who live in high crime areas and depend on government housing should not lose their right to self-defense simply because of where they live. Some courts have found these restrictions unconstitutional under Bruin because they effectively disarm people based on economic status with no clear historical basis. Change number 12. The bump stock ban was struck down by the Supreme Court. This one got news coverage, but most people did not understand what it means for gun law as a whole. In Garland versus Cargill in 2024, the Supreme Court ruled that the ATF overstepped its authority when it classified bump stocks as machine guns under federal law. The ruling was not about the Second Amendment directly. It was about the limits of agency power. But the practical effect is that bump stocks are no longer federally banned. Some states have their own bans in place, so check your state law. But at the federal level, the ban is gone. Change number 13. The overall power of the ATF to regulate firearms through rule changes was significantly weakened. The Cargill decision, combined with a separate Supreme Court ruling that overturned decades of deference given to federal agencies in interpreting their own rules, means the ATF has much less power to create new gun restrictions through regulation without Congress passing an actual law. This is a big deal. For years, the ATF could issue rules that had the practical effect of law. Now, any major ATF rule change is much more likely to be challenged successfully in court. This shifts the power over gun regulation back toward Congress, where it arguably always should have been. Listen, these 13 changes are happening right now. Courts are issuing new rulings every single week based on the framework we just talked about. If you're not staying on top of this, you're navigating gun law with a map from 5 years ago. That map is wrong. The roads have changed. Subscribe right now because my next video is going to give you a step-by-step action plan for what to do with all of this information. I'm going to tell you exactly how to check your own state's laws, what to ask an attorney, and how to protect yourself legally. That video drops soon and you do not want to miss it. Hit subscribe and hit the bell so you get notified the second it goes live. Here's the bottom line. The Supreme Court's decisions in recent years have fundamentally restructured how gun laws are written, challenged, and enforced across this country. 13 distinct areas of gun law have shifted. Some changes expanded your rights dramatically. Others created new gray areas that could trap you if you are not careful. The most important thing you can do right now is stay informed. Know the laws in your specific state and consult a real attorney for your specific situation. Share this video with one gun owner you know. You might save them from a serious mistake. Drop a comment below and tell me which of these 13 changes surprised you the most. I read every comment and I use your feedback to decide what to cover next. And remember, everything in this video is educational and informational only. It is not legal advice. Laws vary by state and they change constantly. Always consult a licensed firearms attorney before making legal decisions. Stay safe, stay informed, and I will see you in the next one.